Good afternoon. I'm Jonathan Fanton, President of the MacArthur Foundation, and it's my great honor to welcome you to a conversation about the role and legacy of the ad hoc tribunals in the emerging system of international justice. We welcome especially members of the diplomatic corps, all those who work in courts and agencies of international justice, and members of civil society organizations that work for peace and justice around the world on the front lines. We gather on the occasion of the conferral of the MacArthur Award for Advancing International Justice on Richard Goldstone. His lifelong commitment to human dignity, equality before the law, and redress for those who suffer great wrongs has helped transform our hopes for justice into a practical reality. Richard Goldstone's leadership, dedication, and high professional standards as prosecutor in the tribunals of the former Yugoslavia and Rwanda helped establish a new era of international justice. He prepared the way for a legitimate, coherent, and credible set of institutions that are bringing perpetrators of the worst crimes to account, honoring the memories of victims, and moving us closer to a world where never again is a promise fulfilled. We have witnessed a period of remarkable achievements. In May 1993, after an interval of almost a half-century, the international community re-engaged with the idea of international justice. 16 years on, we have a set of institutions cohering into an effective system, a growing body of jurisprudence, well-honed procedures, important precedents, experienced practitioners. International justice is no longer merely an aspiration. It is a force to be reckoned with. The UN-mandated tribunal for the former Yugoslavia was a bold experiment. For the first time since Nuremberg, the world had an internationally sanctioned and supported forum in which to enforce humanitarian law. It showed that international norms could be upheld in regional and civil conflicts. ICTY and the Rwanda tribunal that followed set the stage for other hybrid tribunals in Sierra Leone, East Timor, Cambodia. 5 tribunals have tried more than 250 people from 10 nations. National courts, such as the War Crimes Chamber of the Court of Bosnia and Herzegovina, are now conducting trials to international standards. And the example of the tribunals has encouraged other nations to proceed against those responsible for crimes against humanity. The credibility of the tribunals paved the way for the Rome Statute and the International Criminal Court. They gave new vigor to regional human rights courts and commissions in Europe and Latin America, and the new Africa Regional Court and the human rights mechanisms soon dawning in Asia will draw from their experience. We have come a long way. And MacArthur is proud to have worked alongside the champions of international justice in this critical period. Since our founding, we have supported organizations dedicated to human rights and justice, 600 in 90 countries, some like Human Rights Watch and the International Federation for Human Rights are world over. Others, small and local, in places like Russia, Nigeria, and Mexico, are doing important frontline work. We started our international justice grant making over a decade ago. Early grants helped the ICTY explain its work to ordinary people, funded the collection of evidence in Bosnia, trained young lawyers, supported a frontline documentary on Radovan Karadzic. And as the momentum toward a permanent international court grew, MacArthur brought civil society groups from the global south to join in drafting the Rome Statute. Underwrote the Coalition for the International Criminal Court, an alliance of hundreds, now thousands, of NGOs, and helped get the court up and running. We continue to make grants to Redress, Advocates Sans Frontières, the Uganda Coalition for the ICC, the Institute for War and Peace Reporting, and more to strengthen support for the court and to help witnesses and victims participate in the proceedings. And we've supported the International Bar Association to conduct independent analyses of the court's jurisprudence. Beyond the International Criminal Court, we have also taken an interest in regional courts and commissions which provide ordinary people the opportunity to appeal cases of police abuse, discrimination, abridgment of free expression and assembly when they've exhausted remedies within their own national court systems. MacArthur grants to the Mexican Commission for Human Rights and the Center for the Promotion of International Defense in Russia have brought cases to the Inter-America and European courts. And we're helping the new Africa Court on Human and People's Rights as it begins to develop. Regional courts can raise the quality of justice in national courts, and a stronger culture for the rule of law may well prevent everyday abuses from aggregating into the worst crimes imaginable. The world has a stronger arsenal for justice than ever before. While each element had quite separate origins, we are on the cusp of forging an integrated system of international justice out of the disparate parts. The age of impunity is about to give way to an age of accountability. But of course, we cannot be overly optimistic or naive. The road to building a system of accountability is long and challenging. Some countries agree in theory to international justice without the slightest intention of honoring their commitments. Other nations will stand aloof or obstruct the development of the system, and still others try to change the subject, claiming an assault on their sovereignty. The indictment of Omar al-Bashir raised concerns that the ICC had too powerful a mandate, perhaps the beginning of a more widespread buyer's remorse. And in the meantime, the victims of Darfur continue to suffer. But today we're here to talk about both the past and the future and how they connect. We examine the record of the tribunals, their successes and failures, the lessons they have taught, and the influence they have had on international, regional, and national jurisprudence. We affirm their central purposes: to bring justice and insist on accountability, to deter others who would commit atrocities, to strengthen the rule of law in principle and in practice. We examine how far they have come in bringing justice to the victims of appalling crimes, whether they have furthered reconciliation, educated communities, and established a true historical record that honors those who have suffered. And we gather to dedicate ourselves to new efforts to the future. The pursuit of justice should brook neither cynicism nor despair. We accept the challenge because we've seen in our lifetimes the horrific alternatives. We owe this not just to the victims, the dead from Bosnia to Rwanda to Darfur, but to the living. Their courage and fortitude, their determination to heal, rebuild, and move forward in hope should inspire us and stir our resolve to press on with our work. It is my privilege now to introduce the distinguished panel. Each has played a prominent role in one or more areas of international justice. Their biographies are printed in your program, so my introductions will be very brief, just on the connection to this panel. MacArthur trustee Lloyd Axworthy will lead the discussion with the panel and then open the floor to your questions. Luis Moreno-Ocampo will offer reflections after the question period, and MacArthur trustee Donald Hopkins will close the proceedings. Let me begin with David Schwendiman. He was appointed International Prosecutor of the Special Section for War Crimes of the Bosnian State Prosecutor's Office in 2006, and later Chief of the section. He is at the forefront of the effort to establish international criminal law within domestic systems and how international tribunals relate to the hybrid tribunals and national courts. Next, Navi Pillay, the UN High Commissioner of Human Rights and former president of the International Criminal Tribunal for Rwanda and a former judge of the ICC. She bridges the world of international criminal justice and the UN human rights mechanisms. Justice Pillay also has extensive domestic, legal, and judicial experience in her native South Africa. Next, Hassan Jallow. He was appointed prosecutor for the International Criminal Tribunal for Rwanda in 2003. Prior to this role, Justice Jallow was a judge of the Appeals Chamber of the Special Court for Sierra Leone. He was an early advocate for the African Human Rights Commission, and we hope will share his views on the new Africa Court of Human Rights. And finally, Karina Moskalenko, a courageous defender of human rights and founder of the International Protection Center in Moscow. She is one of Russia's leading human rights lawyers and represents clients both within Russia's legal system and before the European Court of Human Rights. She will provide insight on the impact of international and regional judicial systems on national legal systems. And finally, I'm pleased to turn the microphone over to MacArthur trustee Lloyd Axworthy. Dr. Axworthy is presently President and Vice Chancellor of the University of Winnipeg. As Foreign Minister of Canada, his signature accomplishment was the Ottawa Treaty, a global agreement banning anti-personnel landmines. He also played prominent roles in establishing the ICC, the Protocol on Child Soldiers, and the Commission that articulated the responsibility to protect. I can think of few people as well-versed in international justice issues or as well-suited to lead our discussion this afternoon, so please welcome Lloyd Axworthy and the rest of the panel.
Well, thank you very much, Jonathan, and welcome to everybody. At an earlier occasion today, I heard the mayor of The Hague call this city the legal justice capital of the world. And as I look out in the distinguished group that has gathered here this afternoon, I can see exactly what he meant. The wheels of justice have all meshed here this afternoon in a very sort of exciting way, and I welcome you all to join us in a conversation. A conversation, as you know, is defined as the kindly contemplation of the incongruities of life. We will sort of carry ourselves in that spirit that we are here to talk to each other and talk with you about the way in which the system of international justice has both evolved, where it's at, and how we can take stock of both the achievements and raise some of the questions about where it goes from here. It seems to be a good time for that kind of assessments to be made, and I think in particular it's an appropriate way of recognizing and the accomplishments of Justice Goldstone, who played so much part in establishing the basic foundations. So in effect, this conversation really, sir, is very much a product of your initiative and inspiration. So in saying that, let's let the conversation begin. And I'd like to turn to David, if I could. As you see, several people on the panel are practitioners on the front lines of making international justice work on the ground. And David, you've been involved in the Balkans as the special prosecutor now for several years. You inherit the work of ICTY that
Yes.
came before it. I wonder if you could share just your thoughts as, in effect, your own operation begins to wind down because the international community has kind of reached its shelf life on some of the tribunals that we're talking about. What impact do you think the variety of decisions, the many hundreds of decisions, has on actually changing the outlook, the attitude, the performance, the behavior of justice within the Balkans themselves, particularly in your jurisdiction?
Sure. Lloyd, thank you for making me first. I mean, we talked about this a while ago. Of course, the jurisprudence in Bosnia and Herzegovina is built on the ICTY jurisprudence. We've inherited that as a working jurisprudence. It's giving us something to work with. We're building on it as we go. Our shelf life, as you've indicated, is not short in terms of the Bosnian court and the Bosnian prosecutor's office. Our shelf life as an international component of that is short and will end this year. I think it's important that we understand that the contribution that the international community has made to the development of jurisprudence in Bosnia and Herzegovina, and understand that it's probably not time for that to end. But I would say there are two things that the ICTY has given us. First, the working jurisprudence that started with Tadic and the other cases that had to be done in the very beginning has given us modes of liability and definition of elements of crime that we've built on, that Judge Rodriguez, who is here, brought to Bosnia and Herzegovina in his baggage when he came. And also it's given us a pattern of investigation and lessons learned that I think are valuable for the future generally, not the least of which is how we prioritize what we're going to do. So we do what we have to do now, and work our way into the future.
But Human Rights Watch has written a report saying that they have a deep concern about the continuity, that the prosecuting system, judicial system within Bosnia itself is not up to the match in terms of inheriting that legacy that is being left.
Yeah, I think surely the people that I work with, that I manage now as the head of the department, are professionally competent people. They are skilled. They are becoming more and more effective in the system that they've been given. Now, you understand, they were continental lawyers, civil lawyers before 2003, and a system of adversarial justice was imposed on them in 2003, which they are now becoming more and more used to and becoming expert in. So I think one of the reasons that Human Rights Watch took the position it did is that it's not time yet. Things have not institutionalized themselves the way they need to be in order for that to have some future, some long-term future. So they're professional, they're competent, they're becoming effective. The one thing they do lack is a bit of political cover to make decisions now in a highly charged political environment that they need to make in order for the kinds of things that are happening now to continue into the future.
Hassan, I wonder if I could continue that same question again. You're prosecutor of the Rwanda Tribunal, again, which has had a quite sort of broad-scale impact in terms of the prosecutions you've been able to initiate. How was it, again, affected or set precedent, set standards, set norms for the application of those laws and that justice, not only in Rwanda itself, but in the broader sweep of the African continent? Because, again, your tribunal is reaching a certain timeline that the international community is committed. What happens when that stops happening?
Yes, I believe we have had quite an impact in various respects, and I must pay tribute in that case to Judge Richard Goldstone, who is here with us today, and who has helped lay the foundations for that kind of work to be done. The ICTR has had an impact, first in the sense that it's been able to bring to account a large body of people, very senior people, whom it would have been difficult to lay hands upon. Beyond that, and beyond the impact on the development of the jurisprudence, is also the fact that we've had an impact on Rwanda itself, on the development of the Rwandan legal system. A number of law reform measures have been taken by Rwanda, starting with the abolition of the death sentence, the integration of fair trial standards into their laws, the improvement of judicial processes, etc. We've been helping them with training. We've had an impact in the sense of employing Rwandan nationals within the court, and therefore building up the capacity of the Rwandans to take on this kind of work. So we have had that impact on Rwanda. Beyond Rwanda itself, on the continent, of course, these kinds of offenses continue to be committed on the continent, unfortunately. So you can't speak in terms of the deterrence effect of our work as such. We still have the problem of the Congo going on. But nonetheless, there is increasingly a recognition at the highest political levels within the continent that this is an era of accountability, of legal accountability, quite different from the past. I have witnessed sessions of heads of states where everybody assumes that this is an era of legal accountability, as I've said, and this is what has facilitated processes against Charles Taylor, processes against somebody like Hissène Habré, for instance. There's been no question as to whether they ought to be held to account, but the only question has been how they ought to be held to account. And I think the work of the tribunal has helped in creating that atmosphere at the highest political levels in the continent to recognize that there has to be legal accountability at that level itself. At the level of the legal systems, many of the countries have now also engaged in law reform measures which integrate some of these offenses, some of these crimes within their own laws. But of course, most of them still lack the capacity to implement these kinds of laws. And that has come out very, very strongly, for instance, in our efforts to refer cases from the ICTR to African jurisdictions for them to take on the responsibility to prosecute these cases. None of them can take on these cases. Only Rwanda has expressed a readiness, a willingness to prosecute these kinds of cases, despite the fact that most of their legal systems do have these crimes incorporated in them. But there is an issue of capacity in the African countries, which makes it difficult for them to actually take the initiative in prosecute these kinds of offenses.
So what happens when your tribunal then comes to an end? You've really been acting really as the touchstone for a lot of these activities. And we also see a certain pushback on the ICC decisions as it related to the president of Sudan. Do you think there's a balance? Is the balance shifting? Is there a retreat taking place, or is it still being developed and going forward?
I don't think there's a retreat taking place in Africa, a retreat from international criminal justice. There have been certain political concerns expressed recently, first in relation to, for instance, the exercise of universal jurisdiction. Many of the countries complain that as useful as the principle is, and I believe it is a useful principle which we need to retain, their fear is that it is the exercise of power and legal authority by the strong north against weaker southern jurisdictions. So they have expressed these fears. And then secondly, of course, there is a lot of criticism, I believe not well-founded, against the ICC. But these are perceptions which we need to face and which we need to address in order to ensure that the system of international criminal justice continues to function properly.
I want to just, in the same line of questioning, Karina, in your role as a human rights advocate in Russia, could you again tell us what's been the reaction in the judicial system in Russia to the membership in the European Court of Human Rights, and whether it's making an impact? Is it becoming integrated into the law? Is international justice acting as a series of standards and norms and precedents for what happens within the legal process?
The European Court system, this mechanism, this instrument is very important today in Russia. We started with another body. We started with the Human Rights Committee of the United Nations, because Russia was the member or in the jurisdiction of this committee since the 1st January of 1992. And we tried that mechanism, and we, on behalf of our applicants, we won many of all the first cases. But the problem with this body and with these decisions was that, unfortunately, the Russian authorities were not going to follow these decisions, because they say there are some recommendations we would like to follow, but if it is not obvious that the authorities committed some of human rights violations, we of the opinion that we do not have to implement these views, as they are called by the committee. With the European Court system, with this mechanism, it is dramatically different situation. From the very beginning, our authorities have realized that all the decisions and the judgments of the European Court are binding. That was clear from the very beginning. And I would say all the compensations in more than, I would say, about 700 cases been decided for these last 10 years. In all the cases, the compensations were paid to the victims, and this kind of the high recognition of the authority of the European Court. In some cases, there are measures of the, not of the individual character, but of general character. And with this part of the judgment, there are much more difficulties with the understanding of necessity to follow, the understanding of the responsibility to follow their international commitments, and to how to implement. And it is not very easy each time to do that. I mean, if we take as a good example Kalashnikov versus Russia, where Mr. Kalashnikov, who won the case, he was a prisoner in horrible conditions, and the Russian authorities acknowledged all these problems, and they started to improve the penitentiary system. But it is a huge country. It takes time. So they did a lot. They have done a lot, and we have to be fair. But still, it is not the ideal system. Still, we are bringing some more cases to the European Court with more or less the same problems. But the thing is that there were intentions. There was a good political will to follow the judgment. If we take another case, very recent, Kudeshkina versus Russia, very important case. The judge who took the risk to bring to the public awareness the way how judges sometimes are affected by the executive to find this or that decision. And this, what we all say, our problem is lack of independence of judiciary. In one case, it became visible. It is not very often when judges disseminate such kind of the information. And this judge have been dismissed. Firstly, from this case, this particular case, and lastly, from office, from her judge status. And she was so brave to go to the European Court, and we won this case just last month. And the
Congratulations.
And our authorities are not going to recognize that. Eventually, they will. I'm sure. They always do that. But this time, they want to go to the Grand Chamber to appeal, to say that this is not true about the Russian judiciary. But unfortunately, it is truth, and it is not all the truth, I would say.
Okay.
So it has a great influence on the judicial system. Even the Supreme Court of the Russian Federation, we have a very difficult problem with pretrial detention. It is unfortunately not the presumption on release pending trial in our country, but vice versa. All being accused stay waiting for their judgments in prison. It's absolutely abnormal practice, which been reacted by the European Court in numerous cases, and the Supreme Court of the Russian Federation issued a special decree explaining to the judges how they must apply the international norms. I would say this is a great result. Still, we want everything and immediately. We have won about 60 cases for our clients, and most of them are principal cases establishing good case law for the Russian authorities. And we want the Russian authorities always follow these rules, these standards. It's not a fact up to now, but I still hope, on behalf of our clients, we still hope that this system would be enough efficient and effective.
Okay. Thank you. Commissioner Pillay, I wonder if we could pick up on, you have been through a tribunal, a court, and now the Commissioner of Human Rights. How do you see the ability, the capacity of the international justice decisions and the institutions that have been evolving as being essential to the work that you now have undertaken, which is to broaden the culture of human rights and the responsibility to adhere to it?
Well, first, if you'll allow me to greet the people in this hall. I see a number of former presidents here, Judge McDonnell, Judge Meron, Philip Kirsch, and I'm sure that Judge Poka is here. Many judges, prosecutors, of course, just Goldstone, and all the colleagues. So these are the people then who helped to make international criminal justice a reality. So it was a concept. And if you think that it all happened in the short period of 15 years, then this is a great miracle. It took very long, 60 years since Nuremberg. So just have patience in Russia, we're getting there.
You have no.
And of course, Jonathan Fanton said that in my capacity as High Commissioner for Human Rights, my office now acts as a bridge between international criminal justice, because there are very many tribunals and hybrid tribunals, a bridge between that and where we are now with human rights. Yes, I like that idea of a bridge, and I think I'm standing in the middle of the bridge, actually, because I've never left the judiciary. What we see in international criminal justice is accountability for very serious criminal acts. What you have in the High Commissioner's office, a mandate created by the United Nations General Assembly in 1993, is a unique position, the only such position in the United Nations system for the protection and promotion of human rights. And integral to that, you can't hear me?
There you go.
I think he's taking my diamond earring off.
Well, we have to pay for dinner somehow tonight.
Take what off?
It's clear.
This is called a makeover of the High Commissioner.
I was in the middle of the bridge, I think.
You're on the bridge. Let's go back to the bridge now.
So this unique office of the High Commissioner for Human Rights calls for accountability for all human rights violations. And that's where we are. Very often the international courts are criticized for being very selective. For lawyers have said before us, double standards. And as Prosecutor Hassan Jallow has said, Africa has a particular point of view, that the ICC is focusing only on Africa. For instance, the High Commissioner's role is astride the globe and to focus on all human rights violations. Some of the challenges we face, and it's raised with me by victims all over the world, children, every New York taxi driver when I go to the United Nations, is how we do not deliver. We do not deliver on human rights. What exactly are we doing with all our treaties, covenants, and international courts when before our very eyes, on our television screens, we see huge outrages, such as we've seen recently? So one of the challenges that I face and that the Human Rights Council faces is how to bring on the agenda and how to get states to address chronic human rights violations and how to address serious emergencies that arise in very many countries. And I recognize the presence of the President of the Human Rights Council here, who for years has struggled to bring these issues before the Human Rights Council. Let me say briefly about the Human Rights Council, which I service. Also a very special body, and it's only when I got there that I realized the importance of where we are with this new vision. International criminal justice, a new vision of ending impunity, holding serious perpetrators of serious crimes accountable. We never had that before. For very many years, United Nations declared apartheid a crime against humanity, where Justice Goldstone and I were co-victims. But there was no international mechanism where you could seek justice. And as NGOs and victims all over the world struggle to realize human rights, they ask, how can we make states accountable? How can we make states deliver on their obligations? So we come a bit close here with the Human Rights Council, which was created 2 years ago. It's a successor to the Human Rights Commission. In this council, you have a system called Universal Periodic Review. There are 47 members of that council, the United States being a new member earlier this month. But all 192 states have their human rights records reviewed by the council. So it's a peer review by members. It's not necessarily judgmental. It's rather to assistance. Many of the recommendations directs the High Commissioner to assist the particular countries with capacity building and training and so on. Recommendations come from other states to the state concerned, such as we recommend that you ratify the Rome Statute of the International Criminal Court, or we recommend that you do something about ending impunity in your country. So I now see that my duty as High Commissioner is how to best support this Human Rights Council, how to encourage states to take this responsibility of theirs seriously, so that they seriously examine the human rights records of fellow member states. The other interesting phenomenon about the Human Rights Council is that civil society organizations, NGOs and so on, have direct access to this council and can speak to the human rights conditions that they experience in their countries. I don't know whether I've answered your question.
Well,
have I gone off? Yeah.
Aside from the earring, no, that was...
Yeah.
But Commissioner Pillay, I hear an undertone in the comments from the other members of the panel that both with the coming to end of two of the major tribunals, that there may be a bit of a stalling, a plateauing, maybe a better way of describing it, in terms of the international community's investment, involvement, engagement in the advancement of the international justice institutions and practices. Are you saying to us that you think the Human Rights Council can be the instrument, the agency by which that can be revived? In particular, what I guess I'm getting at is that hearing that the tribunals themselves have done wonderful work, but it hasn't necessarily translated into the national state level as part of their jurisprudence, part of their responsibility. Is that something that the Human Rights Council can begin to address?
Well, the tribunals are ad hoc. They focus on particular areas, former Yugoslavia, Rwanda. But we now have the permanent court, the International Criminal Court. It's an essential body because when national states are unable or unwilling to prosecute serious crimes, finally they have a mechanism to which they can refer. And this is what happened. 3 African states, Uganda, Central African Republic, and the Democratic Republic of Congo, actually appealed to the International Criminal Court. Please help us investigate these serious crimes. So that's essential. We have it. That's going to grow because there will always be states unwilling or unable to investigate and prosecute very serious crimes. In my personal experience, I think that the tribunals, also the International Criminal Court and the other hybrid tribunals have had impact in the national states, not only in the states over which they had jurisdiction, but other states. If I may give you an example, the first prosecution of rape as a war crime, crime against humanity, and genocide was in the Rwanda Tribunal. The definition of rape in that was adopted by 2 states in America. Illinois, I forget the other one. You have so many states, so I forget the other name. The South African Constitutional Court referred to the decision in order to amend the Sexual Violence Act in South Africa because the judges realized that the dignity of a boy child and a girl child is the same and they are equally affected, so you shouldn't distinguish between the sexes when you define rape. So I can give you many other examples. The very fact that the states who have ratified the International Criminal Court, that's 108 now, 108. I think, yes, 108. subscribe to the principle of ending impunity. Many of them have applied national jurisdiction. Many of them have adopted national legislation to implement it. And what does that mean? Once again, a duty to prosecute is now in the national system. I can think of other examples. As I see it, I think it's very hopeful. I think that the international criminal justice is not going to die down. It has great appeal, and it will continue to influence national jurisdiction. I get very heartened each time national judges cite international law, for instance. Very recently, that was done by the U.S. Supreme Court in the case of death penalty applying to minors.
I wonder if I could take that question, though, and address it to the other panelists. Did you actually see the evolution of an integrated international justice system? We've talked about individual tribunals. We've talked about the impact that they may have, or in some cases do have, on the national jurisdictions. But do you see the emergence of a system, a framework of international justice in which these institutions actually connect, are linked up? I know that they share certain personnel, they share certain areas, but do you really see the formation yet of an international justice system with a framework, or is this just simply still more of a rhetorical claim?
I think there is a truly international system, even though the current ad hocs are all situation-specific courts, like for us for dealing with Rwanda, the ICTY dealing with Yugoslavia, but institutionally we are linked. For instance, we share a common appeals chamber, and that fact alone has helped sort of harmonize the jurisprudence, unify the jurisprudence, so that there is a single body of jurisprudence at the highest level. Beyond that, of course, as prosecutors also in the various tribunals, we discuss strategy, we share strategies, we share experiences, we look at our objectives. I suppose the judges can't do that sort of thing, but we as prosecutors have been doing that regularly, annually as a matter of fact, in what we call the prosecutors' colloquia. We hold them annually. And this year we have one scheduled for Kigali, where we expect all the prosecutors to attend, and hope also all the previous prosecutors will attend, and discuss the theme of international criminal justice, looking at the past and reflecting on the future. And we hope this year that will give us an opportunity to discuss the directions of international criminal justice at a time when the ad hocs are about to close down, because we believe it's important to do that. Within the next 2 years or so, the ad hocs will close, and then there will be the ICC. How will that affect the structure that has been developed so far?
Can I ask a question? Commissioner Pillay said that the ICC really now has, in effect, replaced the ad hoc tribunals. Is it just the ICC and the national jurisdictions now that will emerge, or do you see something evolving in between? Are there other institutional sort of ideas or models that you might want to look at?
It's possible for new structures to emerge. I don't think we'll have anything like the ad hoc tribunals being created again. We are probably dinosaurs, the last of the breed. Yeah. It's possible you might have new hybrids coming, but...
So you're an endangered species.
we are an endangered species. But recently there's also been some suggestions about the creation, for instance, within the African system, of a criminal jurisdiction within the African court. Hopefully, of course, if that is meant as part of the complementarity regime of the ICC, it's a development which could be supported and encouraged, and provided it's going to be effective as well. So you could have those sorts of developments taking place. It's an idea which has been mooted. There can't, of course, be a movement away from the ICC. I think that would be absolutely disastrous for the process of international justice. But we could see national systems gaining strength. We could see possibly regional systems coming to play a role in criminal jurisdiction, and still the ICC possibly coming in as a court of last resort.
David, what's your thoughts on that?
Well, I come at it from a completely different perspective. I mean, I come at all of this from the national perspective. I mean, my job is a domestic prosecutor in a domestic system. I think we've spent too much time, in some respects, talking about a global structure, talking about international courts, about ad hoc courts, about regional tribunals, and too little time about the domestic courts that are, by and large, going to do the bulk of this work going on into the next 25 or 30 years. And God forbid there should be another incident where we need to do that. It's going to be a lot of domestic work. So to answer your question, I don't think, looking at it from my perspective, that there is a growing structural, integrated international criminal legal system. I see a system that is joined by common jurisprudence, which is what we all ought to strive for. Common norms, common principles that are applied perhaps through different mechanisms, but common principles, common norms nonetheless. And the international community cannot declare victory and say that we've accomplished so much if they now forget the national and domestic systems that are going to be so important come the future. I think the legacy that the ICTY has left, Judge Goldstone and others, is that this jurisprudence is encouraging people to look at things the same way, apply the same modes of liability, force the same development of the elements of the crimes, but again, in their own systems. Should there be a need for another international forensic intervention, and there will be, unquestionably, sometime in the future, we need to understand this concept very well and understand that what we're doing when we intervene will have an effect later on the domestic system's abilities to function. We're going through that right now. Thank heaven for Judge Pokar and Gabriel McIntyre and others who have made it possible for us to begin to realize on what the ICTY has done so that we can use it in the domestic system. But we're struggling, as Judge Pokar knows, in trying to figure out mechanisms for doing that. Those need to be understood.
One of the mechanisms I know when we ratified the Rome Statute, we unbundled it basically, but introduced it into our criminal code.
Mm-hmm, right.
And as you saw, there was a case, a Rwanda case in Canada just last week, where in fact, for the first time, we basically used the Rome Statute requirements within the criminal code, so it became very much a national jurisdiction. Is that something that should be promoted and developed? I'll go back, perhaps, Commissioner, in terms of encouraging countries to be able to put that, so it's not something that is a jurisprudence from the outside, but it actually becomes integral within their own sort of criminal justice system.
Well, if I may, I mean, I'm an American. You're talking to an American here, but I'm not an American employee. I work for the Court of Bosnia and Herzegovina for the Prosecutor's Office. So I would say, in my own view, and coming from that position, that yes, we ought to encourage that because that's where the future lies. Mm-hmm. Whether that will actually happen, whether people accept it from a political point of view or not, is another question.
If I could put a footnote, one of the things that made it happen is that we were providing technical assistance to many countries to show how it could be done, and then that fell off over a period of time. And I'm just wondering, to go back to your statement.
Now I want to ask David, why did he say I'm an American? You don't see any prospects of that happening in America, where national courts will use international jurisprudence?
Yeah, I think the future is there. Mm-hmm. I think it's going to develop that way. I think there's certainly some problems now in getting courts, the Supreme Court, to accept international jurisprudence as sort of a guide, not as a precedent, clearly. But look, I'm very hopeful about this administration. I think that's
I wonder, Katrina, if I could throw the question to you, because you're living it, where you're in a country which is a Security Council permanent member, and you're saying while there is international jurisprudence, the fulfillment of that is limited. What's needed to make that more real?
First of all, what I would strongly support, the opinion that we need more implementation of the standards domestically. We shouldn't forget about the domestic legal system, and first of all, we are trying to plead as much as we can cases nationally, domestically. Or look, if these standards do not work in your country, there would be a brilliant case law at the European Court. Look at the European Court. It's now so popular. This court is overloaded with Russian applications. Now it is 1/3, I believe, of all 100 pending cases before the European Court. But before the country would implement it truly and, really implement these standards in our own country, we would go always to the European Court, we go to Strasbourg. Everybody now in Russia knows that if you fail to find justice in your country, you go to the European Court. But this is not a third or fourth instance. The same, no, not the same with the ICC. With ICC, it's even worse. There are no knowledge on what is the instrument. If you rely on the authorities, they would never disseminate this information. We practicing lawyers were interested in Strasbourg Court, that's why we educate ourselves, and now we are educating many years with the assistance of MacArthur Foundation in Moscow and with the assistance of National Endowment for Democracy. In Strasbourg, we disseminate all this information. We have really interesting and good training courses everywhere, but we have no, maybe I am wrong, my colleagues from Russia would correct me, but we almost have any knowledge on the ICC, and I would say 99, if not more, % of Russian lawyers would say that this instrument is very irrelevant, very far from Russian reality, and we have signed, everybody knows, or not everybody, but at least somebody in our country, that at 2000 we have signed this, Roma Statute. But we haven't ratified, and it's unlikely that in the current political situation our authorities would ratify this instrument. I would be happy. But we are not prepared even for this. I know that many people rely on this mechanism. They send their complaint, they are doing it themselves, because lawyers cannot assist even in doing this. Lawyers say this is just a nice tale story. It's not about Russia.
It seems to me, though, that if that's true, that there's such a lack of information in Russia, I dare say it's true in other places. Is there a breakdown or a failure? I mean, I've been neutered as a university president, but are the academic institutions no longer, why are they, law schools and other areas, not providing this kind of education if international justice system has become so central to the dynamics of what's taking place internationally? I mean, how do we begin to engage the academy, the NGO communities, the forms of communication to disseminate what, in fact, is all of you saying is a very important sort of set of developments in the last 15 years. Commissioner?
Well, certainly all of us have an obligation to disseminate information, and I think the internet and the electronic media is the way of the future. If Obama did it, why shouldn't we use it as well to spread the information? Let me say, though, I know you're speaking from the point of view of the judges, state, and so on. Ordinary people know about justice. They will not ever rest until they have justice for a wrong done. And this is why we have Cambodia 20 years after the event. And there you are. I said in the beginning that I speak for civil society and for victims, and there is a continuing demand for justice. Mr. Ocampo will also tell you he's been to Darfur many times, so that the cry for justice is there. People know that they won't have lasting peace unless there's justice. And I think that the more we educate masses of people, the call for justice, the pressure, the obligation to deliver on duty to investigate will come from the ground up. These are what we have are great examples. And I also wanted to say, when we were at the point about whether international criminal justice is dead or just taking off, I would say it's just taking off because the ICC has territorial and temporal limitations on its jurisdiction. And that's why the calls of victims to their own states would be a call that they will even have to respond to.
That's right. Yeah. And I think the international community has got to step up and support national jurisdictions as best they can to help develop not only capacity, but political will, and use the leverage that the international community has to make that happen. Unless that happens, I think it's not going to go anywhere.
Where do you see the inspiration for that? Surely not the Security Council.
I agree with I agree with the commissioner that perhaps we've spent too much time talking to ourselves and too little time talking to the people that are actually affected by these things, getting out and making the case on the ground.
Do you agree with this?
I think one of the issues we face is that there's been the development of a very large body of jurisprudence by these international tribunals, but getting it communicated to those who need to know it in order to use it has been a problem. That really is not the role of the tribunals. I mean, we target, for instance, Rwanda in terms of dissemination of our jurisprudence and our work. But I think somebody needs to step in.
But whose role is it?
Somebody like the UN High Commissioner for Human Rights.
Okay. You're responsible.
I'm going to ask MacArthur Foundation for money.
There we go.
I think this is a role that the High Commissioner for Human Rights could play to make sure that the jurisprudence that is developed actually reaches the people. Take the principle of command responsibility. It's so important, so critical these days. But how many of our national military authorities in the developing countries are aware of it? It needs to be disseminated so that members of these armed forces are aware of it, and therefore they're able to act accordingly. And as I said, I think perhaps with the help of the MacArthur Foundation, the High Commissioner for Human Rights.
I knew we'd get around to that.
Lloyd, there's one thing about that, and I think when we do this with the public at large, when we talk to the people that are truly affected, we have to make sure that the expectations we raise in them are accurate and realistic, because the surest way to destroy confidence in a national system is to burden that national system with expectations that derive from international tribunals that have huge support and large resources to work with. I know I can speak from experience in Bosnia and Herzegovina that we are a struggling state. We are a state that is just putting itself back on its feet and has continued to struggle with itself inside. The resources don't exist to do as much as the international community may demand or expect of that institution without international help. So I think being realistic is also very, very important.
I was part of the UN Commission on Legal Empowerment for Poverty. The same thing is true in the foreign aid system. There's very little invested in being able to ensure that people knew what their legal rights were, get them legally registered, and being able to provide a system of support for them to use the legal tools in order to be able to make choices for themselves economically. It seems that we're basically in the same kind of box, that there's a real missing issue here, dealing with how the law itself becomes an important sort of instrument.
Yeah. I think it goes directly to the survival of those institutions.
I'm going to sort of now take a moment to invite the conversation to be broadened and to invite all of you to share in. Or Jonathan, do you think, I think you're going to take the wagon master's role and make sure that all these questions are mild and meek and moderate and properly vetted. So I think we have mics on the floor that will be distributed if you raise your hand. So I'll turn it back over to Jonathan Fanton.
Well, the real reason I'm going to take the questions is so that Lloyd can be a member of the panel. Yes. So it's fair game to address questions to him. But before we start, we want to thank the panel for a really thoughtful and stimulating discussion. The kind of mix. Thank you. The mix of realism and vision, a kind of practical sense, but never losing sight of the ultimate objective, gives us a lot of confidence that this really is a system that's emerging and coming together. So let's take some questions. The mics will come around, and if you could keep the questions short and maybe say who you are as you ask the question. This is a fabulous audience. We're all, any one of you could be up here as well. So
frightening or fabulous?
Fabulous. It really is. So let's continue the conversation. Starting back there. Yes, sir. The mic will come your way.
Make us closer to each other.
Thank you. Hello. Yeah. Actually, it's not a question. My name is Fatsa Ougouz. I'm sitting on the bench of the African Court of Human and People's Rights. Actually, I didn't want to take the floor, but since the name of the African Court was mentioned by many times, first by Mr. Jonathan Fanton, and then by my friend Hassan Jallow, I wanted to say some words about the African Court and share with you one of the experience of the African Court as far as impunity is concerned.
And also come to a question, too. So we have,
I don't have a question, Mr. Fanton. Okay. I might just say one word about the African Court. The African Court is a human rights court, actually, but recently it has been asked by the African head of states to help the African Union, the African Continental Organization, to address the issue of impunity. As you know, that the issue of impunity is at stake now in Africa, as well as the issue of universal jurisdiction. There's currently a joint commission of experts between the African Union and the European Union, who has just issued a report on this issue of universal jurisdiction. So the African Court has been asked to make some proposal concerning the fight against impunity, and the court is currently working on this. I'm saying those remarks because I want to go further and say something about my next remark. Actually, my next remark is a frustration, an expression of frustration, but it's not a criticism. It's a very interesting theme, this theme of legacy of the international criminal tribunals in national and international systems. But I think it's very short. It could have been, we could have discussed 2 or 3 days on this very rich theme. Legacy, I'd like to hear more about legacy of international tribunals. This is one point. Before turning to the contribution of the international tribunals. The second point is international system, and I share the view expressed by one of the panelists. I don't see any international criminal system so far. I don't even see any international justice system. And this is my third question. The way the title of the theme is framed, you know, international, national and international systems. I can understand what we mean by national systems, but I don't understand what we mean by international system. So this is my frustration, but it's also a compliment. I mean, and I thank the organizer for having picked up this very interesting subject.
Thank you.
My third...
Thank you. I think we ought to share the mic with some others. So.
I just wanted to say some word about the composition of the panel, Mr. Fanton.
Yeah.
And I think that you've made a very good choice.
Thank you.
Navi Pillay used the expression bridge, and I think it's a very good concept. It's not only a bridge between human rights and international criminal justice, but also between national system and international system. National system and international system. National justice and international justice.
Okay, I'm going to take another question over here. Yes.
Mr. Fanton.
Yeah.
I will give you
honestly, yeah.
But I understood that it was a discussion.
Well, it is, but we have a limited time, and we have many others who wish to be part of it. Over here, please. Thank you.
Bill Pace with the Coalition for the International Criminal Court. I just wanted to compliment the comments made about how important it is to continue to work to expand the jurisdiction of the International Criminal Court by trying to get beyond the 108 countries, and we'll have Chile very soon, which will be 109. But we really need 30, 40 key governments to ratify, and we need the national implementing legislation, and we need to learn how to make complementarity work, and the governments of the Assembly of State Parties have a tremendous amount of work to do, and the institutions. My main question and criticism is that I think the international courts have mainly been seen as instruments for prosecution and not instruments for justice, and not instruments that are looking after the victim. Have any of the institutions actually done victims protection? They've done witness protection, but have they actually gone out to try and help victims? And the second point is failure of all of the international tribunals to do the kind of explanation of its work to the people that need to know it, whether it's the situation country victims or whether it's the academia or others. And we saw with Mr. Jallow saying, that's not our job. It is your job. We're all failing in this work, and we all need to do much better because we have a very catastrophic situation public relations-wise, especially in Africa.
So let's take the question on protection of witnesses. Who would like to...
Well,
Victims.
Victims protection. Let me talk about that just a little bit.
Yes,
and then
yes.
On the national side, one of our biggest challenges is that we get the victims back as witnesses and as those who are affected by what we do after the ICTY and the international tribunals get through with them, and perhaps 3 or 4 times they've gotten through with them. We get them back in the national system with little or no programmatic way of helping them with their problems, getting them relocated, getting them services. My older witnesses in the Akmenci case, which was mine, they kept asking me, I need to go somewhere, I need to get out of here, this is the only place I can live, I don't want to live here anymore, but I have no mechanism for doing that. I think more and more needs to be done on the international side to support failed states and to support those post-conflict states so that they have the resources to actually do that kind of thing. I don't think it's the role of the International Tribunal to go in and repair the lives of the victims that they use as witnesses. But that's just my view.
If I may.
Yeah, sure.
I mean,
Go ahead.
Because most of the work, the outreach work that we do at the tribunals is funded from voluntary contributions, not from the regular budget that is provided by the United Nations. And this is just an indication of the fact that the member states don't even expect us to do that. We only do it if they wish to and they support us through their own voluntary contributions. It's of course work which needs to be done, and we focus very much on Rwanda, trying to explain to the Rwanda people the work we are doing. We are opening a lot of information centers in Rwanda. We do a lot of outreach work, disseminating information. But beyond Rwanda, I think for practical reasons, somebody else has to come in and assist us. We cannot reach out to everybody. And so somebody who can do some targeted dissemination of our jurisprudence and the kind of work we are doing should step in and assist us. You are quite right, of course, ICTR and ICTY have not built in anything for the victims within their own structures. It's been a major criticism of our work. But the world has moved beyond us now to the ICC, where there is some recognition of the need to pay attention to the role and the plight of victims. So some lessons have been learned from the defects of the ICTR statute and the ICTY statute in the shape of what has been provided in the ICC Rome statute in relation to victims.
Karina, did you
may
want
I
to...
say something? Yes. Yeah. May I say, yeah. So I'm one of the guilty ones who writes these 300-page judgments. Now, who reads these judgments? So we do have a duty to explain the judgments, issue it in a form where media can follow the impact of a decision. So I think that is a failure, and Bill is quite right to point to that. We do have a duty to explain our product to the people for whom it matters. Now, on the question of victims, where victims are witnesses, then all the tribunals have provided protection, relocation, and so on. You're quite right that even the ICC may not have the capacity to protect all victims who are not witnesses. If we, the practical side of me says if we go that route, you may not get the other ratifications that you are seeking because it's so vast and so costly. The International Criminal Court has already issued very important decisions, also groundbreaking, on the rights of victims to participate in court proceedings, and they will get to the right of victims to reparation because that's in the statute.
Did you have
if you allow
sure.
2 words, surely we never used ICC, as I explained it, but using the mechanism of the European Court of Human Rights, we always with our victims, and these victims, they are entitled not only to participate in the proceedings with the legal concept of state positive obligation, for example, on right to life. Using this concept, we always bring our cases to the European Court in order to say that, for example, several journalists and human rights activists been killed in our country. The authorities, they say, we failed to find those criminals, we cannot punish anybody because we will simply have unsuccessful investigation. And then we say, if the investigation was ineffective, if you haven't done anything to prevent this killing, if in another case, Nordost case, where hostages been killed not by the terrorists actually, but by the using rescue operation and using poison gas, we apply with our victims of this attack, more than 100 victims we had there. This concept, legal concept of positive obligation of the of the state on right to life, saying that they haven't prevent people deaths, they haven't prevent journalists killings and things like that. And this is living instrument which produce these new concepts, precisely in the area how to protect victims' rights and not only accuse somebody in doing something wrong.
Good. I have a question in the center.
Is this on? Good afternoon, Erika de Wet, Universities of Amsterdam and Pretoria in South Africa. I have 2 critical questions, one addressed to Madam Pillay and one addressed to Madam Moskalenko. The one concerns the proliferation of human rights courts in Africa, in the different regions of Africa, and the potential that this has for lowering human rights standards and even shielding on the African continent. I think that this is a bit being glossed over during this discussion. Adding criminal jurisdiction to the African court is not necessarily a good thing. There are serious reasons to believe that this is considered exactly to shield the likes of al-Bashir and others from real prosecution. I would like to hear what the take of the High Commissioner's Office is on the proliferation of human rights jurisdiction, in the sense that ECOWAS, the SADC courts and a variety of regional economic courts are now claiming human rights jurisdiction as well, and how this may play out in the long run in terms of human rights protection in Africa, especially in relation to their relationship with the African court, who is supposed to be dealing with these issues. My second...
Got to make it brief, because we have a long line here of people.
I'll just put it in one line. I'm just rather surprised about the overemphasis on the positive aspects of Russia's membership in the Council of Europe, because it seems that in the large instances of cases, the Russian government doesn't give effect to any of the decisions against it, and that actually its membership in the Council of Europe is directly contributing to the collapsing of the system as it is.
Okay, we'll start with the High Commissioner first.
Well, I think we're all engaged in the business of watching out for pseudo-courts that claim that they are dispensing justice with its human rights. Once again, to the Human Rights Council, there we have an independent body composed of national human rights institutions, grading the national human rights institutions of every country. So if they comply with Paris principles, that's its independent and proper standards, then they have A grade. Some states, Sri Lanka, for instance, was stripped of its A grade. So that's a very interesting route that has been applied to national human rights institutions that can, I think, be applied to these institutions that are mushrooming up. I would take I was not aware of that there were so many, and particularly in Africa. Also, it's my duty to watch out for such institutions in the whole world, not just Africa. But I will, get my office alert to these institutions.
Actually, you are the first person in my life who criticized me for loyal point of view on what the Russian authorities are doing. My life in Russia is so difficult now that part of our office now moved to France. And thankfully, this country gave us an opportunity to create an association in Strasbourg where we continue our office and keeping our archives in order to not them to be, you know, eliminated by the Russian authorities. And you can imagine after the winning so many cases how we are loved by our authorities. But I always want, as I said, everything and today and immediately. But what I was trying to say today, unless the Russian authorities not implementing judgments of the European Court in sense of the measures of general character, because of sometimes lack of understanding what to do, lack of good political will, real political will, and other reasons. But what I was trying to explain, that even this negligent authority, which not always implement judgments fully, they recognize the authority of the court. They never say that we will not implement the judgment, we will not pay the compensation. And what is the most positive thing, unless I more or less agree with you that with Russian participation that the Council of Europe, the system can collapse even. What is the most important thing, that instead of the Human Rights Committee at the United Nations, where nobody they check if the judgment decisions were implemented, but they have no mechanism to force the country which is not going to implement no one judgment, no one. I'm telling about Russia. At the Council of Europe, we have a committee of ministers, which every 3 months check all the implementation of judgments. And it works. It not work as effective as we want, but it works. That's why I am positive, not towards the Russian government maybe, but towards the system, the mechanism which can be used, still can be used. Thank you for your question, by the way. And thank you for blaming me to be very positive.
Thank you, Mr. President. I would want to encourage the MacArthur Foundation to continue its mission in promoting justice, both at the international level and at the regional level, particularly in Africa. And the panel has been excellent in its presentation this afternoon in presenting the background to these issues. I'm at a loss. Some have heard it said both by Justice Jallow and by Justice Pillay that there is talk in Africa that the ICC in particular is an imposition by the North on the South. I just don't get it. I don't know what we're talking about. And thankfully, I'm an African. African governments participated fully in the elaboration and construction of the Rome Statute. So I don't see, it's not like traditional international law where it was argued that Africa was absent. We were there at the beginning and in Rome. So I don't see what African governments can complain about. But if some governments do complain, I was at a meeting over the weekend, in a legal meeting, and I was told that every day, 1,500 Congolese are dying every day, here as we speak. So if you say that there should be, or those culprits should not be brought before the International Criminal Court, who is there to speak for the people, for the Congolese people who are dying every day? Who is there to speak for the people of Darfur? So I don't think we should pay much attention to those criticisms which have been made. I want to encourage you here, Mr. President, that for the civil society, the International Criminal Court would not have been in existence today. I think what we have to do is to strengthen civil society in African countries and to make sure that African governments, African leaders are subject to the rule of law. So we should not buy into the argument that the International Criminal Court is an imposition. The people of Darfur won't tell you that. The people of Congo would tell you that, who are victims of the warlords. So I just want us to say that we should strengthen the civil societies in African countries to promote the Rome Statute and the jurisprudence of the International Criminal Court.
Thank you. Thank you. Very powerful statement. Take one more question right over here, in the middle of this row here. Thank you very much for that statement.
Thank you. My name is Gabrielle Kirk McDonald. I'm now a judge with the Iran U.S. Claims Tribunal, but my heart and soul is still with the ICTY, where I was for 6 years. I have a question and a comment. My comment is really a follow-up to Bill Pace's comment, and that is the role of international criminal courts in assisting victims and witnesses and their societies and even perpetrators with to live in justice, in peace and security. We must remember that the resolution that established the ICTY provided that the tribunal was being established to help to bring about international peace and security. And there was the belief that prosecutions would help to bring about that peace and security. What we found at the ICTY, and what I found at least, was that what we were doing, we were issuing wonderful judgments, these 300-page judgments that Judge Pillay spoke about, but that people in the region for whom the tribunal was established didn't get it. They didn't know what was going on, but what they felt was that this was an attack on them. They didn't understand the processes. So what we did then, with the help of the MacArthur Foundation, was to establish an outreach program to, as you said, Mr. Fallon, very well, to explain to ordinary people what these judgments were all about. So I think that it is the role of international criminal tribunals to bring the word to the reality, to the reality of the victims and witnesses in the region. Otherwise, all that we're doing is preparing judgments that are very beautiful. They break wonderful international criminal law ground, but they don't do too much to help the people. Now, the question, though, that I had relates to a question, Mr. Axworthy, that you raised, and that is the joining of the legal jurisprudence of the tribunals. Of course, there will be some joining of the legal jurisprudence with ICTY and ICTR because of a joint appeals chamber. But my question is, what do the panel members feel is or will be the effect of the genocide case that was decided by the International Court of Justice? There are certain pronouncements were made about the conflict in the former Yugoslavia. And there, perhaps what we're looking at is not so much a joining of the legal jurisprudence of the tribunal, but perhaps an attempt to create sort of a primacy or a hierarchy of international criminal courts. So I'd like to have your opinion about the possible effect of the genocide judgment.
Who would like to tackle that? Lloyd? You
Well, not really, but let me comment that from the perspective of someone who was in politics for 30 years and played some role internationally, what we haven't really described is that the so-called international justice system is a system of tribunals. It's not like a national justice system, which has policemen and has a judicial department. It has a much wider variety of people and places which make up a justice system. Here, you can have an international tribunal, but then you're totally reliant upon the goodwill or the volunteerism of certain countries, nation states, to be able to implement it. And I think that what I hear from the panel today, what I've seen before and what I hear from you is that we won't have a fully functioning international justice system until you put some more ingredients into the soup. That there's got to be, I don't think the tribunals themselves are designed to be public relations communication specialists, even though there is an incredible magic in today's information systems to get information out and disseminate it. But you used the expression Obama, but Obama brought in all the smartest gee whiz kids to put his whole system together. That is not part of what we call sort of the international justice system, and I think that therefore we have to shift the paradigm a little bit and broaden it out and talk about a true international justice system, one that has some much clearer responsibilities for the political bodies, in this case Security Council, or in the cases Council of Europe, or the cases of the African Union, or wherever it may be. Secondly, the instrumentation that goes with it, the ability to actually apprehend people in an effective way, which I think has been a real negligence on the part of, quote, international community players, those of us who are signatories to the Rome Statute. And thirdly, just the sheer mechanisms, which may come through the Human Rights Council. I don't know well enough its future agenda, but to provide that information, communication, and training. Because I am embarrassed, as I said, as a university president, to realize that our law schools and so on simply aren't teaching this issue. It's not broadcast through the International Bar, even though there's, I think, an incredible enthusiasm and cadre of young men and women who would love to be part of it. So I want to argue for an international justice system that really is a system, and not simply one that sort of is based purely just on tribunals. I think that you're really putting the pyramid on the top of its point, and that maybe that's one of the expressions that should come out of meetings like this, is how do we begin to develop a framework that really does have all the tools in the kit box that you need.
I think that's an excellent closing statement for our panel. Yes. So let us thank the panel for a terrific job. And we'll have a chance during the reception to get to some of the questions that went unasked. And I now have the privilege of introducing the prosecutor of the International Criminal Court, Luis Moreno-Ocampo, who is here to offer reflections. The ICC has been much in the public spotlight recently, and I think that's a sign that its work is having impact worldwide. The prosecutor has been courageous in his determination to bring the most prominent perpetrators of atrocity to account, and yet it remains to be seen whether the international community will honor its commitment fully to global justice. If, as I believe, the court is the most important international institution founded since the UN itself, its early cases, the cases now coming up, are critically important. So we hope those nations that have ratified the Rome Statute and others that wish the court well will stand behind the court and enforce its arrest warrants. That's critically important. And we salute Luis Moreno-Ocampo for his determination to make the ICC a potent force for justice, his passion for the rights of victims, and his eloquent defense of the court and its mission on the world stage. So it is my great honor to introduce my friend, Luis Moreno-Ocampo.
Thank you so much, Jonathan. Not just for the introduction, also for organizing this gathering. In fact, we are not meeting so often between us, and it's interesting. We are not discussing with you what you are doing at STY, what you are doing in the past in STY, what Navi Pillay is doing. And thank you, because Jonathan Fanton started with this idea, I think, last year in Waldorf Hotel when he gave the award to Kofi Annan. He started to put us together in a different way. And I think this is very important for us, because basically, as the ICC is a global institution who has, the mission is clear, ending impunity to contribute to the prevention of future crimes. But of course, we are a piece in the prevention of future crimes, and even in the ending impunity too. So we cannot work alone, and we have to learn how to interact with the others. And Jonathan Fanton is helping us to do it in operation. He helped me a lot to connect with other institutions who are working with us. He designed this idea, had the vision to do it 1 year ago when he organized a meeting in the Waldorf Astoria. And now with this award to Richard Goldstone, that is someone to follow, is helping us to keep thinking on this idea. And just to show how this is going beyond Jonathan Fanton, because Jonathan is leaving MacArthur Foundation, but MacArthur organized a big meeting in New York in September this year, where we have the opportunity to integrate. And as you see today, it's not easy to discuss between us, because there are so many conflicts. Just between lawyers, in the justice area. Richard Goldstone once told me the problem he had at the beginning of his tenure. 3 of his prosecutors went to his office and said, this place is impossible. The American prosecutors say, I cannot work here. In 3 weeks, we have a witness, we have to prepare the witness, and my colleagues refuse to prepare the witness. It's not a professional place. The British lawyers say, in England, I will be disbarred if I prepare a witness, so I cannot be disbarred to work here. And the Scotland lawyers say, in Scotland, prepare a witness is a crime. I cannot commit the crime to work here. And this is a detail. So imagine if lawyers who have this problem to discuss between us, a detail, imagine when we discuss a genocide or rule of disclosure or these issues. But in any case, more or less, we are doing that. We are learning each other what the different tribunals did, and we are setting standards. And it's very important for us, because we are at peace, but our peace has to be perfect. So it's very important to have the highest standards of disclosure, the highest standard of fair trial, the highest standard of accuracy in our decisions. So that's why this connection between us is so critically important. But then, as some of you say, I think you say that, we have to go talk to the other, And here, they are the others. They are journalists. There are people here doing radio programs in Congo. They are managers, people doing, even in our own courts, there are so many works. The registrar had to protect witness, run a prison, run an IT system, do the outreach that Bill Bates is criticizing, everything. So it's so complex and so many tasks that it's not just about judicial activities. It's about how to liaise with the others. And that's why I admire the vision of MacArthur, because they organize a meeting in which we cannot discuss concepts. So we cannot discuss if we can prepare a witness or not, because it will be endless discussion. But we'll discuss what we will do. Simple. So basically, each organ, judges, prosecutors, registry, presidents of the assembly, NGOs, will discuss what we are planning to do. And that will help us to integrate. And I think it's possible to integrate. Talking about international justice and national justice, I believe this international justice, the permanent system, ICC, with the consequence of the ad hoc system, so we are evolving, ICC and the regional courts are together both trying to move the national systems. Regional courts are reviewing the standards. And we are working just in exceptional cases when they cannot, are unable or unwilling, as Pillay explained. So in both cases, we are showing a new idea. International justice is not something different. It's integrating national systems. And that, I think, is what we are trying to develop, how to understand this, how to work together. But then you have the other aspect, how to repair the victims, how to rebuild institutions, how to communicate what we are doing. And this is beyond judges, beyond prosecutors. And that's something I hope in New York we'll do it. So just to give you an example of what we are planning to do to explain better our activities, what the prosecutor will say. We'll explain, okay, we have this in the next 3 years, we have at least 2 trials. We are doing Lubanga trial. The prosecutor case is finishing in June, so we are finishing the prosecution case. In Lubanga trial probably will be some witness for the defense, so probably next year, the beginning or middle of next year will be the decision. In September, we are starting the Katanga case, the second trial. The confirmation hearing of Mr. Bemba is around June, this month. In October, we are starting the confirmation hearing of Mr. Abu Garda, one of the rebels commanders who attacked Askanita bases. And that is the work we are doing in the court. And as you say, and I like very much what you say, we are giving a voice to African victims. And we are guilty, yes. We will not ignore African victims. We'll work for them. That's the point. I agree fully with you. Imagine in Rwanda, if people ignore the Rwanda victims, because you care about the victims in Africa, you are against Africa? No, no. We are providing justice for the African victims, working with African leaders against those who commit the crimes. But the second aspect we'll present, and that's something I'd like to share here, is because now the court is working, the impact is much bigger. And for me, the best example is what's happening in Kenya. Because Kenya is a pure African solution for a Kenya violence, but they all the time are talking about ICC. ICC is the front page of Kenyan newspapers, even we did nothing. And that's because the commission who investigate the crimes talk about if Kenya is not doing cases, the ICC has to intervene. And that trigger activities and discussions in Kenya, and they will define how to do it. Colombia is similar. The Attorney General in Colombia said very clearly, we have to do the cases, if not, ICC will come and do the cases. And they are doing many cases, many investigations. I just personally was in a mass grave investigation where they have 7 forensic workers reviewing a mass grave, 40 soldiers protecting them because it's still a violent area, and 2 investigation teams investigating who committed the crimes and who was the owner of the place. And all this is just one of the cases Colombia is doing in order to avoid that doing justice for themselves, knowing that if not, ICC will do it. Similar in London. In UK, they have the ICC Act investigating crimes committed in Iraq because, yes, they know if not, we'll do it. And that is a new model. International justice is not that we are taking cases. It's just a complementarity system in which national states have to do it. And talking about Russia, let me say something about Russia. As soon as Russia starts operations in Georgia, they start to send to us communications about crimes committed in Georgia. 3,000 communications we receive. Maybe you are skeptical, but at least means that Russia was thinking in the ICC when they start the operation, and they plan how to deal with the ICC and the Rome Statute when they operate in Georgia. And that is new, and that is happening. And, okay, we also received the Palestinian authorities who came to my office providing jurisdiction, and that's the way in which we will interact with the High Commission for Human Rights, because I understand Richard Goldstone, with great courage, accepted to be the head of the fact-finding commission to investigate what's happening in Gaza. So that's what I see is happening, and it's coming, and I'd like to tell you, because then you have to think how different pieces have to integrate all this work. And that will be a possibility we have in September. So let me finish, because I think that is the idea. The main idea is, thank you, MacArthur, because you are helping us to integrate our work, even if we cannot define conceptually what we are doing, but we can understand who is doing what and how to work together. And I think we have to be privileged for the work we are doing. We have the privilege to build these institutions. And as you say, just in 15 years, this is coming, changing how the legal system is working in the world. Even the change is so dramatic that we cannot even explain. Legal scholars are behind us. We are moving faster. And so they cannot describe what we are doing. And that's why I feel privileged, but also I have particular privilege to be today here, sharing with you this ceremony to recognize the work of Richard Goldstone. Because I suppose Jonathan will explain what Richard Goldstone did. But for me, I knew his name when he was working in the Goldstone Commission in South Africa. And I met him after. And he has, I would say, 3 aspects of his personality who are very interesting for me. I'm trying to follow, but not yet there. He is precise. He's firm, and he's very gentle. And that's a perfect combination. So I try to be... The last part in particular is not working very well in my case. And I'm trying to improve, okay? But I think you really choose very well. You're very good choosing those who receive your reward. Because last year, he gave the reward to Kofi Annan before Kofi Annan solved or worked in the Kenyan case. And this year, you decide to give a reward to Richard Galston for all what he did. But as you know, probably the most important activity of Richard Galston is yet to come, because he's now he had the courage, I know was approved by Hague's authority, he had the courage to lead this fact-finding committee to investigate abuses in Gaza. And for me, that is incredibly important, because he has the prestige, he has the courage to do it. He will win nothing more than hate. So what I can promise you, the ingratitude of many people, but we celebrate what you are doing, and I'm very glad that you will receive this Justice Award.
Oh, Luis, I think you have a gentle side. I think we see that. The selection of the awardee is done by a committee of the MacArthur board, and our chairman, whom you'll meet later tonight, Bob Denham, and Lloyd Axworthy, who is chair of the committee, and Don Hopkins, who heads our international committee of our board, all are part of that decision process. And it's my great pleasure now to introduce Dr. Donald Hopkins. He's Vice President for Health Programs at the Carter Center in Atlanta. He's an acknowledged leader in public health, and his current passion is to eliminate the waterborne guinea worm parasite, and due in large part to the leadership he's given. The incidence of guinea worm has declined 99.7% since 1987, from 3.5 million cases a year to only a few thousand, and it stands ready to be the next disease after smallpox wiped off the face of the earth. Dr. Hopkins is witness to the power of hope, determination, and well-targeted practical measures in overcoming seemingly insurmountable challenges, and that's not a bad theme for the work that draws us all together. So it's my great pleasure to introduce MacArthur trustee Donald Hopkins.
Well, good evening. Justice Goldstone, members of our distinguished panel, ladies and gentlemen. First of all, I'm sitting here wondering what is a former pediatrician to do to parse the work of this distinguished panel, its legal work. I'm reminded, however, as a human being, having seen in my work so much misery of a scholar in the Middle Ages who was becoming blind, I suppose from cataract, was offered the opportunity in his very advanced years of having surgery to get rid of the cataract so that he could see better, and he declined, saying that he had already seen too much misery of this world. As I sat here listening this evening, I think of maybe two main audiences for the great work in seeking to bring peace and justice to people. One audience are and I have to tell you, most of my work has been in rural areas of Africa, but I see the one audience as the people out in the villages, people whose main challenge day in, day out is to educate, feed, and clothe their children. The need for them to be relieved of some of the burdens of people who are oppressing them unjustly. I'm often reminded also that people will tolerate a lot until they see that that's really not the way things should be, and especially when they see that next door people aren't doing like that. And I think one advantage of modern communications, in addition to, is that it helps to bring many of these atrocities into people's living rooms in a way that previous generations had not seen them. The second audience is the perpetrators and would-be perpetrators of such atrocities. The word deterrence has been mentioned here several times. And while we're not there yet, I think of the counterpart of prevention and public health is deterrence in this area of politics and legalities. Among the consequences of the indictment of President al-Bashir, I think of the saying in Hollywood that there's no such thing as bad publicity. Has been a lot more people have learned about the systems being put in place for people to have redress when they are being put upon by others. And there have been lots of other things that have been raised in connection with that: peace versus justice, the alleged power of certain states versus weaker states, racial transgressions from the past, which remind me of another favorite quote of mine from William Faulkner, the American novelist, that the past is not dead, it's not even past, he said. And I think in connection with al-Bashir, as in many other instances, we've seen people use what are in fact legitimate grievances to twist efforts, legitimate efforts, to make people rise up under false pretensions. And I think we have to seek to guard against that. But a lot more people, and I know if I were a would-be perpetrator, I would be worried, seeing what's happening now. And I've often tried to imagine, how is it that people can do some of these things and without success in imagining that? I do feel I can imagine people at least giving or having pause now, seeing what's happening in the world and the architecture that's being constructed here to help bring perpetrators to justice. In public health, finally, the holy grail for us is eradication. And I hope that soon we'll be to that point. In addition to deterrence and bringing hope to the people at the grassroots level in rural villages, they will get to the point of eradicating these kinds of atrocities altogether, even before they begin. Thank you very much.